If you're the initial aggressor in the confrontation, the first person to threaten or use force or to provoke the use of force against you, you lose the element of innocence, you lose self-defense. Now, it is possible to regain self-defense, even if you were the initial aggressor, and you can do that under two circumstances. One is by withdrawal in communication. You withdraw from the fight, and you communicate that you no longer wish to fight. Now, for the fight to continue, the other party has to come to you. And that essentially starts a second fight in which they are the initial aggressor, and you've regained the element of innocence for purposes of self-defense. Another way you can regain innocence, even if you were the provoker, is if what you provoked was a non-deadly force confrontation, and the other party responds with unlawful deadly force. If you start a non-deadly force confrontation, the other party is privileged to respond with non-deadly force and lawful self-defense. But if they unlawfully escalate to deadly force in response to your non-deadly force threat, again, that effectively starts a second fight, a deadly force fight in which they are the deadly force aggressor, and you've regained the element of innocence for purposes of self-defense. Now, there is a form of provocation where you cannot regain innocence under Wisconsin law and some other states, and that is called provocation with intent. So if you provoke a fight with the intent of having an excuse to use deadly force against that other party, then you cannot regain self-defense by withdrawal and communication. You simply own that fight forever for the duration of the fight. And this, for example, might be the person who says, go ahead, throw the first punch, I dare you. It's not because they want to be punched in the face. It's so they want you to throw the first punch so it looks like they have a legal justification for using force against you. The law doesn't like that because it appears that you're attempting to game the system, to wrongfully use the laws of self-defense to unjustly claim legal privilege for using force against that other person. So they punish what they consider an aggravated form of provocation with intent by denying you the ability to regain self-defense. Yes, and this came up in the mattress trial, right? The mattress dumpster trial. The father and son confronts the big steroid guy dumping the mattress. And the father continuously says, take your swing. The guy takes a swing and the father and son shoot him. Now, the father was convicted. The son was not. Why? Well, the son did not engage in provocation with intent. He never said that provocative language to the other party. The father did. So the son had a credible narrative of self-defense and defense of others. The father just completely undermined his own justification by having been a provoker with intent. So that's the element of innocence. Next element, imminence. The threat you're defending yourself has to be something that's actually occurring or immediately about to occur. Now, whereas innocence is going to be a big issue in dispute in this trial because of matters like, did the defendant provoke the confrontation? If he did provoke the confrontation, did he have the option to withdraw from the fight and regain his innocence? If he did provoke the confrontation, did the other parties respond by a use of deadly force against his threat of non-deadly force? And if so, were they then the unlawful deadly force aggressors in a second fight in which he'd be justified in using deadly force, the knife, to defend himself? So there'll be a lot of contention around the element of innocence in this trial. Imminence, probably not so much. I mean, the fight was ongoing. So there's no question that there was a delay in response to a threat, or someone left and came back, for example. So I don't expect imminence to be a big issue here. Proportionality will be an issue for sure, because ultimately the defendant used deadly force in self-defense. And proportionality has to do with the notion that the amount of force you use in self-defense is effectively determined by the amount of force you're being threatened with. So if you're only being threatened with non-deadly force, like a shove, you can only use non-deadly force in self-defense. You can't use deadly force in self-defense unless you're being threatened with a deadly force threat. Now, what would be deadly force in self-defense? Well, if you're using a weapon in a manner to cause death or serious bodily injury, that would be deadly force self-defense. So you'd need to be able to show that you were facing a deadly force threat. Does that mean the threat has to have a weapon too? No. The question would be, was the threat I was facing one likely to cause me death or serious bodily injury? There's lots of ways to get there with a positive answer. One way could be disparity of numbers, which we certainly have here. Another way is we have an environment here where there's weapons that are not things that were designed to be implements that are weapons. For example, just the water itself. So if there's 2 or 3 people holding your head underwater, are they inflicting death or serious bodily injury upon you? Of course they are. They're drowning you. So that would be a use of deadly force by those persons, even though they're not striking you or stabbing you or shooting you. They're using force in such a manner that it's likely to cause death or personal serious bodily injury. That would be a deadly force threat against which you could use deadly force in self-defense, assuming, of course, the other elements of self-defense are also satisfied. Avoidance has to do with whether or not there's a legal duty to retreat before you can use deadly force in self-defense. It only applies if retreat is safely possible. So even if this were a duty to retreat jurisdiction, and there's only 11 of those, that's very much the minority position in the US. Even if this were a duty to retreat jurisdiction, we'd have to ask, well, would this defendant have had a completely safe avenue of retreat under these circumstances? And the question of retreat is not at any point in the confrontation did he have an opportunity to retreat, because that always exists, right? We could always kind of wander away unless it's an absolute ambush scenario. The question is, at the moment you have to make the decision to use defensive force, at that moment, did you have a legal duty to retreat? And if safe retreat's not possible, then even in a duty to retreat state, it would not be a legal duty. You can't have a legal duty for something that's impossible for you to do. In any case, Wisconsin is not a duty to retreat state. It's a stand your ground state. I'll show you that law in a bit. There is no legal duty in Wisconsin to retreat before you can use deadly force in self-defense. Having said that, it's a soft stand your ground state. So in a hard stand your ground state, and there's about 13 of those, in a hard stand your ground state, the jury's not even allowed to consider the possibility of retreat in evaluating your claim of self-defense. In those states, the element of avoidance is completely off the table, assuming it was an otherwise lawful case of self-defense. The majority of stand your ground states, however, are soft stand your ground states. And in those states, you don't have a legal duty to retreat before you can use deadly force in self-defense, but the jury's allowed to consider whether or not retreat was possible and whether or not a reasonable person in your circumstances would have taken advantage of that safe avenue of retreat. And if a reasonable person would have, they can conclude your failure to do that was unreasonable. And reasonableness, as we'll see in just a moment, is an independent element of self-defense. So if your conduct is deemed unreasonable, well, then it can't have been lawful self-defense. It's kind of a backdoor way of attacking your failure to retreat through the element of reasonableness instead of through the element of avoidance. And finally, the element of reasonableness, and this will be a big one here. Reasonableness really has 2 facets. The first is, did you have a genuine subjective good faith belief in the need to act in self-defense as you did? And that's almost invariably the case in most what I would call good guy cases of self-defense, that the person acting in self-defense, if you ask them, put them on a lie detector, they'd say, yeah, no, I needed to defend myself, and the lie detector would say they were telling the truth. But the second facet of reasonableness is objective reasonableness, meaning would a hypothetical reasonable and prudent person have shared that subjective belief? What this means is the subjective belief cannot have been irrational or speculative or imaginative. It has to be a reasonable, objectively reasonable subjective belief. If a hypothetical reasonable and prudent person would not have shared that subjective belief, you fail objective reasonableness, you fail self-defense. And I'm sure the prosecution here will argue that even though this defendant may have subjectively believed he was facing a deadly force threat, that belief was unreasonable. And that gets us to the doctrine of imperfect self-defense. So if you have all the required elements for self-defense, it's perfect self-defense. And if the jury buys your argument of perfect self-defense, and we'll talk about the burdens of proof here in just a moment, if the jury buys the argument of self-defense, you're acquitted. You have 0 criminal liability. Absolutely none. So you were charged with murder. You walk out of court a free man on the grounds of perfect self-defense. There is a doctrine called imperfect self-defense recognized by many states and recognized by Wisconsin, the relevant state here. And what imperfect self-defense says is you have all the elements for self-defense except objective reasonableness. So you have innocence, imminence, proportionality, avoidance, subjective reasonableness, subjective good faith belief in the need to act in self-defense, but that subjective belief was irrational. In that case, you can qualify for imperfect self-defense. And what imperfect self-defense does is it does not get you to an acquittal. You're charged with murder. You don't walk out of court a free man. Only perfect self-defense can do that in the self-defense context. And you lost that because you didn't have objective reasonableness. What imperfect self-defense does, if the only defect in your claim of self-defense was objective reasonableness, it mitigates what would have been a murder conviction down to a manslaughter conviction. Now, manslaughter is no fun. Manslaughter is typically good for 10 to 20 years in prison, but it's not life in prison without possibility of early release. You might be sentenced to 10 or 20 years in prison and be eligible for parole in a third of that time, depending on the state. So you might be out in 3, 4, 5, 6 years instead of life in prison. So manslaughter sucks as a conviction unless the alternative is first-degree murder. So those are all the kind of abstract elements of self-defense, the up to 5 elements of self-defense.